I'm Andrew Rowe of the Law Office of Andrew Rowe. This video has helped to unpack some estate planning options and things for you to be thinking about if you're in a situation where you're worried about potential court battles after you're gone, or if you're needing to disinherit or specifically make sure some people are left out of your planning options and making sure they're not notified because we're worried about court battles. So unfortunately, family disputes happen all the time, and especially in my decade plus experience, as soon as mom and dad are gone, as soon as that loved one is gone, once money gets on the line, if there are cracks in the foundation, it can really come out after your passing or once it's time to sell the house, divide the proceeds, etc. And so sometimes we do want to get ahead of any chance for court battles, and proper estate planning is a really important piece to that. So in these situations where we are worried about potential court battles or disputes, or we need to disinherit someone, there are a few options to accomplish this, but ultimately, I'll cut to the chase. I generally recommend a trust to accomplish your estate planning purposes, and I'll unpack why that is. When doing estate planning, there are usually ways to accomplish estate planning objectives by setting up a will and having your intentions of who your beneficiaries are in your will, of who to include or who to leave out, and then we can rely on beneficiary designations alone, or we can set up a trust. If I set up a will, and in your situation when we're worried about court battles amongst the beneficiaries or we're disinheriting heirs, things like that, a will has to go through probate. And that usually creates a very big problem in these situations. Kansas has a very difficult and complicated probate code. We are a unique state that we are required to notify not just the beneficiaries under your will, but every one of your heirs at law about your will and give them a chance to object. So what that means is, I'll give you an example. If you have 4 kids and we are needing to leave one out for whatever reason, maybe they've got addiction issues, maybe you've had a falling out, you don't want them to receive the property. If I write a will, Kansas law requires us to give a copy of the will to your children because they're your heirs at law. And so that one child who we intend to leave out will be mailed, and legally we can't move forward until we know that they've had a copy of the will itself that says they're left out. And then there will be a paper that says, if you object to the validity of this will, show up at this date and time. We have to schedule a hearing to allow them to object. You don't need an attorney for that court hearing. So if that person says, I'm not getting anything anyways, I'm just going to show up and object and increase legal costs, they can do that. They do that. The most litigation I've encountered has involved people without attorneys showing up to these court hearings because they just want to wreak havoc. And that's just the way wills work. In order for us to capture your intention and write it down, a will has to go through probate. And the way probate is structured is that any time we want to take an action on your estate, opening it, selling assets, filing an inventory, closing the estate, making distributions, it follows this procedure of petitioning the court to take an action, notifying all interested parties, setting a hearing, and then at that hearing giving an opportunity for objections, and then the judge will issue their order. And so that means that if you're worried about legal battles or disinheriting people, probate requires us to serve everyone on a silver platter their chance to wreak havoc, increase legal costs, and eat up your estate. And it's why anytime we're worried at all about disputes or squabbles, it's best to avoid probate. And you may even be thinking, well, there are options to have contest clauses in your will. And the contest clause, also called in terrorem, say that if anyone disputes the validity of this document, they're deemed to be disinherited. And those work in theory. That can calm down some court disputes and battles. If you've written a will where you've disinherited someone, they're already disinherited. They have nothing to lose to show up without an attorney and just say, I disagree with the will. Just something that simple can change the dynamic of the probate case, because now the attorney who's moving along with the probate has to prove the validity of the will, find some witnesses, get doctors' opinions, get witnesses on the stand, and actually go through a trial. Different animal altogether, costs quite a bit more. And so when we have potential objections, probate just gives them that easy chance to wreak havoc on your estate. So that leaves 2 other options for how to divide your estate upon your death with probate avoidance techniques. One is through beneficiary designations, and one is through setting up a trust. If we rely on beneficiary designations, that can avoid probate, but it doesn't allow for any sort of backup planning. And if you have real estate in your name, there's an issue with that. Because the goal is, if you're wanting your property divided to any more than one person. So let's say you have a house and you've got 2 kids or 2 intended beneficiaries. If we transfer it directly to them, that means they become the owners. Now, they may not want to live in that house. They may want the cash after selling the house. So they've got a job to do. They need to liquidate the house. In order to sell the house, it takes time. You have to get a real estate agent. And in Kansas, it requires both people to sign off on the deed for the house and their spouses. So it takes 4 signatures for those 2 people if they're married. So if 2 people own the house, it might take 4 signatures to sell it. And all 4 of those people have to have capacity to sign the document. And if any of them die before the house gets sold, guess what? Their share has to go through probate in order for the house to have authority to sell. So that then just pushes it down the road and increase a greater risk. The more people involved with the real estate, the greater the chances that any one of them who needs to sign off on the house becomes incapacitated or dies before we can get the house liquidated, which creates all the more problems. So relying just on beneficiary designations is a risky move unless you have only one heir or one beneficiary that you are intending to transfer the property to. So if we rely just on beneficiary designations, it doesn't really allow for any sort of contingency planning, saying what's going to happen if this intended beneficiary dies or is incapacitated or something happens with it. We're then at a loss. That's where a trust would come in, because a trust is designed to avoid probate and its divisions happen without a judge looking over the shoulder of the trustee, which also means that we're not required to notify people who we don't want involved in your trust. So if you're leaving someone out, they may never be the wiser that you ever even had a trust, let alone that they're not included in it. And the trust itself can allow for all of these contingency plannings and saying, well, if the person who we want to sell the house is deceased, incapacitated, can't do it, out of country, here's who's next in line. And then if our beneficiaries are deceased, here's who gets it next. Oh, if we have minor beneficiaries receiving property, here's our plan. Here's how we're going to make sure they're taken care of. Trusts allow for that contingency planning and cover more than just that baseline, here's who gets the property. It asks, what if? Let's solve this next problem. And so that's why I generally recommend, when we're worried about disputes, squabbles, or disinheritance, that we would set up a trust to keep it out of probate court and also to account for any sort of backup planning. So all of this you need to speak with an attorney about. Don't go online and fill out your forms based off of this advice. There's a lot more details that go into choosing this type of estate planning package. But this is meant to get you to start thinking about what plan might be appropriate in your situation. This isn't legal advice. The actual choosing of an estate plan needs to be something you discuss with your attorney. Reach out to our office. We're happy to set up an appointment with you to go over it. What you don't want to do is take this video and go online and use this to guide you about what package you need. There's a lot more details that go into it that need to unpack. This is a starting point of discussion for you to have with your attorney. But we'd be happy to help you out. If you're in a situation where you are needing to address those potential disputes, squabbles, or disinheritance, please reach out to us. This is where we can really help. What we want to do is make this go as smooth as possible and reduce as much headache as possible for your loved ones, giving you that peace of mind. Give us a call.